Today, Free Market Foundation is now First Liberty Institute, and I'm very pleased to be able to introduce Clark Whitley, who's the Development Officer on the Ministry Relations team for First Liberty Institute. Clark joined First Liberty in 2017, and he's responsible for Southeast Texas, and that includes Houston. First Liberty is now the largest and nationwide defender of religious liberty, which Clark will talk about. Prior to First Liberty, though, Clark spent 22 years in business development for the recruiting and accounting industries, including oil and gas. Clark received his bachelor's degree in marketing from Franklin Pierce University, and while at Franklin Pierce, Clark was on both the men's soccer and golf team. And so when not spending time with his family, he's an avid cyclist, golfer, and outdoor enthusiast. So please join me in welcoming Mr. Clark Whitley.
Still working. Thank you, Russell, for having me. Thank you, John, for having me. I appreciate it very much. Y'all hear me okay? Yes. When Russell called me last week, I was getting ready to fly out to California, and thankfully I returned. But I said, you bet, I would love the opportunity. I'm familiar with your organization. I have been to a meeting in the past when you're in another room. And when I was in the recruiting world, I was also familiar with a lot of the companies I'm sure that have graced the walls here. So what I'm going to do today is just give you guys my story. I'll tell you a little bit about me, and then I'll tell you how that became, and I became an employee of First Liberty Institute, and how that relates to a lot of the things that we encounter on a daily basis. And so my story is, I was your typical guy who went to college and grew up Episcopalian, carried crosses, lit candles, wore these fancy robes, and things like that, but I really didn't know Jesus. And enjoyed my college life, and then my second semester senior year, I was introduced to a gal, and she asked me one question. She goes, what do you know about Jesus? And of course, I gave her my answer, knew who he was. But fast forward, I moved back down to Houston, Texas, because I was up in New Hampshire. All my family is from here. We were born here. Lived away for a little while, but came back, and kind of forgot about that conversation for a while. Started meeting a couple people, and somebody brought me to a Metro Bible study here at First Baptist. And kind of lit a fire again in my curiosity again, and once again I kind of drifted away. Well, let's fast forward that story to about 12 years ago. 12 years ago, I met a lovely lady who I'm proud to say today is my wife. She was my neighbor, and we struck up a friendship. I would go inside her house, and I would see devotional on her desk because she worked from home. I would see her Bible on her desk. I would see scripture on the walls and things like that. And just one day, I just felt compelled and convicted, and I said, can I go to church with you? And so at that point, she was a member of Second Baptist Church main campus just over here at Dr. Young's church. And a few weeks later, after going every week, I walked down the center aisle and professed my faith in Christ. And a little bit longer after that, got baptized in the church and just started meeting a bunch of folks there, and became a deacon with the church. And we have since moved out of town. We're out in Columbus now, and we've joined a new church out there. But that's really my evolution of Christ, and meeting good friends and attending Bible study fellowship. And it's kind of my story as my testimony. I give it all to my wife. You know, I'm thankful to her. And God, honestly, for having her devotional on her desk and having her Bible and just curiosity. I know there's been a couple times in my life where I listened, and that was one of them. I was thankful for that. She will tell you, I don't know about that, but anyways. Fast forward to First Liberty. I was sitting in a room, and similar to what Russell described, Kelly Shackelford was in town in someone's house. And I didn't know who he was. I didn't know who Liberty Institute at the time was. And I watched him tell a little bit of the story I'll tell tonight, and piqued our curiosity. And 3 years after that point, I was at a big lunch. God just grabbed my heart, And he said, this is what you're meant to do. And so I got my boss's phone number. There was only 3 people. I actually sit on the ministry relations team. That is the department that I'm in for First Liberty. And I waited a month and a half after I got his phone number, and I cold called him. I told him what my story was in the business world, that I was a recruiter. I was putting people to work at these oil and gas companies and these other Fortune 500 companies. But I just feel like God's telling me you guys can use some skills that I have. And he admitted on the phone, he said, our board of directors just opened a position in Houston. And, okay. 6 months later, I would start. That was in 2017, December 4th, for First Liberty. I've been there ever since in our ministry relations team. We now have 13 people in my department. I was the 3rd person in our department. So when you kind of cover a vast area nationally, you need a couple more people. Texas is big enough, and I got most of it, so I can tell you it's pretty big. But let me tell you a little bit about First Liberty and kind of what we do. Russell mentioned it. We are the largest nonprofit, solely dedicated, legal institution solely dedicated to defending religious freedom. That's all we do. So if you take a look at what religious freedom is, where that is, that's the first half of the First Amendment. And so that's where we operate. But what I think I will do first is just let Kelly explain it to you on a video, if you don't mind.
What we do at First Liberty, every case we win is a ripple effect for the future. We're the nation's largest nonprofit law firm exclusively defending religious liberty for all Americans. With God's favor, our record at the Supreme Court is 9 wins and 0 losses. We win cases that change the culture. For example, this constitutional law book was printed in 2013. A legal precedent called Lemon versus Kurtzman had been the law of the land since 1971, and the Lemon test was cited over 7,000 times in cases to restrict religious liberty. But in our victory at the Supreme Court for the praying coach, Joe Kennedy, Lemon was overturned. And we're still seeing the ripple effects. It brought more freedom for teachers and coaches to publicly express their faith. Religious monuments can go back up. It put nativity scenes back up on the courthouse square. Menorahs, too. It got the national motto placed in public schools. And Christian books can be read in public libraries. Here's another bad law we targeted. The precedent of Trans World Airlines versus Hardison denied people of faith religious accommodations in the workplace since 1973. When we won our case defending the U.S. postal worker Gerald Groff 9-0 at the U.S. Supreme Court, the legal standard changed. Now all people of faith have more freedom to live out their beliefs at work. Religious holidays can be freely celebrated. Service members can receive accommodations for their faith. And the impact of our victories doesn't stop there. Law books are being revised and reprinted. Law school curriculums are being modified. Lawyers are getting retrained for changes in the law. HR departments are updating employee handbooks. But some ripple effects aren't that great. Our victories bring more efforts from our opponents to overhaul the court. The more we win, the more they won. They're desperate to radicalize the court so they can start winning again. They want to pack the court with more justices and end lifetime tenure, starting with conservatives. But to warn Americans of the danger, we turn ripples into waves. Through educational articles, interviews with thought leaders, news appearances, online resources, election events, plus TV and radio nationally. We've also launched our new Judicial Legacy Project, the nation's main resource for identifying quality judges. Winning just one case is significant, but every judge affects thousands of cases. And we're helping put hundreds of judges on the bench for life. But it's not easy, it's not fast, and it's not cheap. But with God's favor and your help, we can continue to win cases and cause ripple effects for future generations. First Liberty. Join us in fighting for what matters most.
So that's a really good video just released last week, but what I'm going to do next is just unpack some of that and what Kelly had by giving you a couple examples of cases that take place in our country that the results of those 9 Supreme Court cases and why you sitting here today have more religious freedom than you've ever had in your life, whether it's walking down the street or in business. And so we've kind of touched on some of those things with the cases that we've had the opportunity to have. And then one of the last things he talks about is a review program of potential jurists that are being nominated by the current president, or any president for that matter, and the role that we play in that, because it didn't exist before we took that on in 2016. So this is one of our cases. This is Heather Rooks. Heather Rooks is just an everyday stay-at-home mom. Election rolls around. As we know, elections have consequences. She didn't like the results of local election cycle in the state of Arizona. And so what she chose to do was get involved. Right? We all get involved one way or another, whether it's financial support somewhere, or in her case, she ran for office and she won a school board seat in Arizona. Well, this particular school board allows 2 to 3 minutes at the beginning of their meetings to essentially speak, say what you want. You can do anything you want with your private time here in front of the school board. And what she chose to do was to quote some scripture verses. They amended everything that said, I'm sorry, you can't use scripture verses. And so we got a hold of this, and her private time, is you have, and you're a private citizen, you can do anything. You're not representing the school board at that time. And again, she quoted scripture verses. Well, they had a big problem with that, and they brought a case against her. And in that case, it's now ongoing. We're 2 years into it, and we have a hearing in August to be able to defend her. But we let the school board know, but they're kind of sticking to their guns. They're a little bit stubborn on that. So that is one of our pillars, is in the school area. And so we'll see how it goes. So be in prayer over this individual who all she wanted to do was quote the Bible. And so this next one is going to fall in one of our 5 pillars. It's our faith-based pillar. And this is Pastor Chris Savella. This guy, we learned of him when he acquired a second building in a small town in Ohio. He runs a church up there called Dad's Place. And in Ohio, if anybody's ever been there, John, you've been there, it gets a little chilly in the summer. Or in the winter, it gets a little chilly. Well, in this case, he saw the opportunity to leave his church open 24 hours a day. His church happens to fall downtown. And there was homeless folks in this downtown of this little community, and he wanted to bring them in out of the cold. And out of the cold in this case was 10 degrees. And so, as you know, that's pretty cold. So he felt convicted, biblically speaking, to open his church. The mayor didn't like that, because the mayor didn't want those kind of people in downtown church. And so she sent the fire department in, the chief, to fine and cite him. He's been cited 18 times criminally for leaving his church open for 24 hours a day. We lost at a lower court in this case. We took it to state level court, and it's still ongoing. There's an injunction stopping the prosecution against him. He's been, because he could end up in jail just for keeping people warm. And the Attorney General of Ohio found out about this and asked us to come meet with him. So we sat down with Ohio's Attorney General, and he was in tears at the end of the meeting learning Pastor's story, and he said, I'm going to get behind you. And so he's fighting his own local municipalities that are courts in his state on our side. And so we think that we have a really good shot at winning this case. We'll take it all the way federally if we need to, but now that it's a state level, we've already won once with the injunction to stop what they're doing. We just have to complete the process, and he should be allowed to leave his church open for 24 hours a day and, I don't know, keep people alive from freezing to death. But that's that. And then October 7th, almost a year and a half ago, we all know what happened. We saw cases explode against the Jewish community in our country. Saying some of the most horrific things, seeing some of the most horrific things. Well, this happens to be one of those cases. This is a pastor who had the idea to open up a synagogue right near a couple other churches in Florida. And so the HOA wanted nothing to do with a synagogue being opened. He followed all the rules and all the process to do so because, again, where he was going to open this synagogue was right next to a couple other houses of worship, churches. But this particular HOA wants nothing to do with the Jewish faith. So much so that they put that on the record to say this. This really happened. We have this on the record. This story repeats itself all across the country. We see this all the time, but that's not over in Israel. That's here in Florida. So good news on this case, it's ongoing. We have won. They are appealing to prevent this guy from opening up from him opening up a synagogue, but we should win that because what we're trying to do is inform the HOA, hey, you can't discriminate. We have this small thing called the Constitution. So, that's very real, and it's painful to read, but it definitely exists. The next slide that I'm going to talk about is about our marketplace, which is another pillar that we have in the marketplace. It covers kind of a wide funnel, but Valerie Klusterman is a health professional out of Michigan. Her mom was a nurse at this particular medical facility that she works, and she's a physician's assistant, and she just wanted to live out her faith, loved going to work every day. University of Michigan bought out this privately held medical facility, and then it became University of Michigan Health Network. Well, that came and ushered in a bunch of big facility rules, policies, things like that, right? And one of those policies was for her to prescribe either certain medication or participate in certain sex change operations, facilitate those processes. Well, she's a woman of faith, and that's not something that she wanted to do, so she asked for a religious exemption, which under law you have every right to do, and she asked for that. Right after she asked for her religious accommodation to not do those things, she was brought into the Human Resources Department. She was called a bigot. She was called all the worst names she possibly could be called, and then subsequently she was fired. And the human resources person essentially looked at her and said, you need to change the way you believe. You can't have your own personal convictions because you're a horrible person. So we picked this case up. We've just had a hearing at the, initially everything usually starts local level with us. The other side tried to petition the state of Michigan to say, hey, let's dismiss this. Well, we went over them and we went to the Sixth Circuit Court of Appeals, and we've had a hearing there. We're waiting for the ruling. So we took it federal as soon as they tried to have it dismissed. So this could have huge sweeping changes for employers. Depending on how the Sixth Circuit rules, it could really dictate major policy changes for Human Resources Department or what employers can and can't do. And we obviously hope that we can keep as much religious freedom in the workplace as possible. And here in a minute or two, I'll get to something that shows you why you have more freedom. The next one that I wanted to show you is this is our Alaska Airlines case. During the last administration, the first year of the last administration, there was a piece of legislation that was in Congress. It didn't pass, but it was called the Equality Act. The Equality Act would have been terrible for houses of worship, would have been terrible for people of faith, because what it sought to do is make everything, quote unquote, equal, right? Your church would have had to have so many LGBT people on staff, or things like that. That's the whole purpose of what that was. It was a terrible piece of legislation and it failed. But Alaska Airlines, what they chose to do was endorse this piece of legislation. And they, on their in-mail, decided to say, we want all of our employees to publicly state that we support this legislation. Well, Lacey Smith, flight attendant, she sent back one question. At what point do we cross the line of morality? She was on her flight schedule because she's a strong believer. She was brought into human resources, pulled off of a flight. Her flight schedule was canceled, and then she began to be called horrible names. You're a terrible human being. You're, again, a bigot. Your faith has no play here in your employment. And ultimately, she was fired for this. Well, this has been going on for quite some time. We're about year 4 into this case here. We are going to have a hearing in October for this one at the 9th Circuit in San Francisco. So that'll be interesting. You're laughing, I know why you're laughing. But there's good news about that. I can honestly talk about that. That Court of Appeals was almost flipped. It's only 14-16 now, based on the previous administration. So you guys are like, great, this guy, he shows up, he gives us all this doom and gloom. There's good news. We have a way to deal with these things. We have a methodology to deal with these things, and we have a track record of doing it. So the way First Liberty goes about doing what we do and why we have the success we have. Kelly thought of an idea as he took a step back in a time of prayer. He said, I think I'm being told to use the Fortune 500 method. So if I have a case in Houston, Texas, and pick a big, huge company, I'm Exxon, I'm in Houston, Texas. I'm not going to fly someone from an attorney from New York. I'm not going to fly an attorney from Chicago, where all the big houses are, or LA. I'm going to hire somebody here. I'm going to bring somebody in who knows the market. I'm going to bring somebody in who knows the jury pool. I'm going to bring someone in who really understands the lay of the land and the local market where the case is going to be. And so that's the methodology that we follow. The way we did that is we have a pro bono network of attorneys, right? So the picture behind me is Joe Kennedy. Joe Kennedy's case lasted for 7 years, right? It took that long. We went up to the Supreme Court twice. Thankfully, on the second time, we won it. But all along the way, we had some volunteer attorneys. And the final volunteer attorney is a guy by the name of Paul Clement. Paul Clement is the former U.S. Solicitor General for the country. There's no one in this country that has been to the Supreme Court more times than Paul Clement. Paul Clement's been there 113 times. If I'm Exxon, I'm calling Paul Clement to represent me at the Supreme Court. That's who I'm going to call. He called us and said, hey, Kelly, I know you've got this case going up to the Supreme Court. I'd like to volunteer my time for that. So he came to us. Paul Clement, if anybody knows who he is, he charged about $2,500 an hour, right? So here's the fun thing about the Pro Bono Network. Coach Kennedy, he never paid a bill. None of our clients ever pay a dime. It's free for our services for the entire time. Now, I wish we could take every single case that exists. We just can't. We were asked, I think it's 7,000 times last year for cases. We took 350. But let's talk a little bit about some of these Supreme Court cases. So this one right here, this is Bladensburg Memorial. This happened 5 years ago, right after I started. And this case is all about this monument. This monument right here is a 100-foot cross. It sits in a traffic circle in Maryland. It has sat there, it's been there since 1919 when it was constructed in honor of World War II Gold Star mothers. For all the warriors who didn't come home, it's their memorial. Well, over time, through eminent domain, this falls now in the middle of a traffic circle. Right? Traffic circle is city-owned. It's no longer on Legion private property. And so one day a guy was driving down the road, and he happened to be a member of a humanist society, right? Anti-faith society, and it offended him. And so he petitioned the court. He brought a case. How are we spending government funds on a cross? This case started local, went to the 11th Circuit Court of Appeals, and at that there was a particular judge who had a solution open in court. His solution was, I tell you what, why don't we cut the arms of the cross off and nobody will be offended. That was his solution. So we knew we were going to lose there, and then we appealed to the Supreme Court. But when this case went to the Supreme Court, we actually ended up winning it 6-3. But there was something really key in this case. There's a law called Lemon, right? So Lemon, and you heard Kelly mention it in law books, Lemon was a religious test for government, right? So that was passed in 1973, same court that did Roe v. Wade, and it basically said that government could apply a test, or if somebody was offended by faith, they could go to the government and they could say, I'm offended by this, and the government could say no faith on property, right? This is where separation of church and state and all that stuff that actually isn't in our Constitution started being thrown around. Well, in court when we were going, we thought that we really want to win this case from the monument perspective, but it was specifically talked about that in open court asking if they used Lemon in this case, and the other side said we actually didn't use Lemon, and the jurists all said, well, if you're not using Lemon, they left it standing. They just kind of mentioned it, but they didn't strike it down. So it's still floating there. But because of this case, governments were given the permission to ignore Lemon, right? But again, it was still there, so still being used. So fast forward, I'll come back to Lemon here in just a minute, but I want to talk about these people real quick. These people have been to the Supreme Court 2 times. Right, this is the Sweet Cakes by Melissa. You see her there out of Oregon. This is the case that she made custom wedding cakes. There was a same-sex couple who decided to come in and ask for a custom wedding cake. And these were actually clients of theirs. They had bought many, many things from Melissa. And she politely said, I just can't make a custom cake for you. It violates my religious beliefs, my faith beliefs, and she said, but I can set up an appointment with you with a good friend who can take care of that. And they did. And the same-sex couple went along their business, was actually quite happy. They ended up talking about it publicly, but the municipalities in Oregon caught wind of it, and they brought suit against them, right? And so what ended up happening to the Kleins, and believe it or not, it's still going, it's 13 years later, they were fined $135,000. It's the largest penalty ever given, given by the state of Oregon. And then they were told this: you may not publicly talk about your religious marital beliefs. They were, which First Amendment. Hi, how you doing? So that's what ended up happening. So again, it's gone up to the Supreme Court twice. The last time it went up there, which was a year ago, it was sent back down again, but all of the rulings below were vacated, and so essentially it starts over. But they are convicted. They think to themselves, what should we do? What are we going to end this? Are we not going to fight anymore? Because what does that say to our children? They have moved out of Oregon. They now live in Wyoming, and she now has another cake shop, but they continue to fight. So there's that. These guys. This is. You guys are hearing a lot about school choice right now. Texas is getting ready to pass school choice. The Texas Senate did. Now it goes over the House. Lots of states are doing this. This case is in Maine. This case, the state of Maine has some interesting laws, right? So there's not a school in every community, and so what the state of Maine does is your tax dollars can follow you wherever you choose to go to school. You can go to school wherever you want. In the early 1980s, they passed a law. However, you can't go to a school of faith with your money. You have to pay for it. So your money can follow there. So this family wanted to go to a Catholic church, a Catholic school, and wanted their money to follow them, and they were told they couldn't. And so we brought this case. This case went all the way up to the Supreme Court, where we subsequently won it, which opened up the opportunity for school choice. But it's not just school choice that opened up, because your tax dollars can follow you. What it also did is it opened a window for homeless shelters or drug rehab centers that are all faith-based now to be able to get funding directly from the government. Right, so that's what this case did. It was pretty earth-shattering to allow, school choice is great, but also to allow centers for the underprivileged that are faith-based to get grants, to get funding from the government. That's a ton of money. And so to be able to take care of our populace. So it was a big, big case for that victory. Now I will say, this case is back on, because the state of Maine didn't like losing, and so what they ended up doing, it's under a different name, but it's essentially the same. The state of Maine passed a law saying that if you want this public funding, even if you're faith-based, you have to teach LGTB policy and things like that. So that's, they're still going. They couldn't let well enough alone, but we're still fighting. So there's that. And then I'll bring it, oh, sorry. Since we're all in the work world here, this is a really important case with Groff. He was a postal worker. Gerald Groff was a faithful carrier. He was a missions guy overseas for a long time. He came back to the U.S. and he made a commitment to God. I'm not going to work on Sundays. It's just not going to happen. So we went to work at the Postal Service. Great idea. They don't work on Sundays. Until they sign contracts with Amazon. And now they work on Sundays. And so in his case, he asked for religious accommodations. He worked overtime. He picked up second and third shifts, things like that. Well, the postmaster in the area that he worked in, Pennsylvania, decided that wasn't well enough alone. I need to force this guy to work on Sundays. So instead of getting a federal firing on his record, he resigned, and then he brought a case against the post office. So what ended up happening when this went to the Supreme Court is there's a case called Hardison that was decided some years ago, which defined what we would call undue burden. Basically, what it said in this case some time ago was that undue burden was, if I'm minorly inconvenienced and I don't like what you're doing, I can deny you your religious accommodation or your exemption. Well, when we went to the Supreme Court, we decided to say, you guys, all 9 of you know that this is a terrible ruling, this is a lie, this is not right, and we won the case 9-0. And so what ended up happening, any employer now, or any employee now has more rights. They can ask for a religious holiday accommodation or any of that, because the employer now has to prove undue burden. They have to say, like in Gerald's case, he picked up all these extra shifts. The employees actually liked it because they went, oh great, I can have the day off, great, you'll pick it up, thank you. Every holiday but a non-religious holiday. And so what that has ended up doing is giving each and one of you as an employee or an employer more power. And so that's a bit of the more religious freedom that we're talking about. Now in his case, started over. The post office during the last administration wanted to keep this case going. And so they were back in court. So we're really curious to see what happens now. Even though they've rewritten that precedence, that's a new precedence now that we set. We're curious to see what this administration will do, if they'll carry this case on or if they'll let it go. But we were really happy with the victory there. And then the last one, we all know who Coach Kennedy is, right? He's the coach who was fired for praying, taking a knee. He's got a great movie out, Average Joey. They did a really good job telling that story. The biggest thing about this case that happened is Lemon. I mentioned it with the Bladensburg Memorial Cross case. They mentioned that, but they didn't overturn it. Well, in this case, during the hearing, we had a decision to make. Go for victory for Joe, for Coach, or what we could do is go to get rid of Lemon altogether. Well, if you're in the bottom of the 9th and your bases are loaded and all you need is a single to win the game, to drive somebody home, that's what you're going to do, and that's what we did. That's what we chose to do. That was our strategy for the case when we went. In the middle of the hearing, Justice Kavanaugh brings up and says, what's that thing about lemon? Did you guys use lemon? What's going on? I mean, and he started talking back and forth with Gorsuch. And when the opinion came out in June, we're sitting there reading the case, and Coach Kennedy's like, did it win? They're like, yeah, be quiet, we're reading the rest of the thing. And so, because he's a very excitable guy, super guy, but they had shredded lemon. They'd ripped it in half. And so it was no longer the precedence of the land, right? If you recall, I said it was passed in 1973. Well, what happened in the 50 years leading up to this ruling was 7,000 cases were decided on lemon. All of those now get to be overturned, right? And so when we take a look at our cases, when a case comes in and we're being asked to hear it, we go into a room, we discuss the case. I'm not involved in this process. I just talk about those guys. They're way too smart for me. And we pray over them all. And part of that prayer time and part of that discussion is, will this make an impact for others who might have this case? Right? Will it create a new umbrella that cases can be decided? And that's what Coach Kennedy did. Right? So Coach Kennedy never wanted a penny. He didn't want anything. He just wanted his job back. That's it. Right? And so that is kind of the things that First Liberty is up to. So we launched a new department called Restoring Faith in America, and which is this. We have a person who sits in San Antonio, and she's going one by one in all these cases to turn them over, to restore all of those cases and reverse them all. So again, more freedom than you ever had. And there's a bolt-on piece to this, and then I'll open it up for a question. You heard Kelly talk about review of judges, jurists, things like that. Well, in 2015, probably most of you, we were preparing for one female person to win, and we were getting ready, because no matter who's in office, we're going to defend religious freedom. It's just what we do. We're nonpartisan in that way. Well, then this Trump guy won, and something really unique happened that should never happen, and almost never happens. There were 135 open federal judge positions that were left. They were open. It was a mistake. And so we took a look at that, and we came up quickly with a strategy with board approval to say we should start reviewing judges. We found out a couple things in that process. We found out that nobody was doing that. We found out that even the Federalist Society, who we get along with really well, we work with, it was more of a, this is a good guy, yeah, he's my buddy, they'll do really well. Well, what we decided to do is we decided to read every opinion that every single judge has written. Right. Fast forward to today, well, let me say first, in the first administration, we reviewed and placed 232 judges on the federal bench. Those positions are for life. When Trump took over office in the first administration, the average age of the more conservative constitutional side of the court was age 67. The average age of that court now is 49. That's what those 232 positions did. Now Biden put a whole bunch of people in there. He did. But as we enter this new administration, there's 160 positions open again. And so if you ask yourself how many federal open seats there are, federal judge positions there are on a national basis, there's 800. So quick math will show you by the time Trump leaves office, he will have placed half of the judiciary. And the folks that we're looking at when we go through this review process, they're folks who are strong on religious freedom, because that's our first filter, and they're also strong on the rest of the Constitution. They're strong in their belief systems, they're strong in what the law actually says. And so something that you have to pay attention to when you read these is that's the proof. And so nobody was showing the White House the proof before. And so Gorsuch is sitting where he is because we read the proof and let the White House know that the two people in front of him were folks that probably didn't want on the bench because we supplied the evidence. And so if you think about this is probably more difficult to do than the cases that we have. I mean, the cases law and things like that was great. So if you take a look at Texas right now, there are 8 federal positions of justice positions in Texas. I think that's something like 66,000 cases that they have opinions on. We'll read every one of those. Now take that and multiply that by 160. All that information and all that process is done in our DC office. We give it to the White House, we give it to the DOJ, and we give it to the Judiciary Committee. So we give all that information so they can make decisions based on, well, facts, not this is a good guy. So, anyways, a lot of fun to do that.